Good evening and welcome to the next in Libro's webinar series to help make money better. Tonight, we are proud to present the roles and responsibilities of an executor. My name's Paul McQueen. I'm the VP of Wealth at Libro Credit Union. I'll be your moderator and host this evening, and we're pleased to be joined by Doug Carroll from Aviso Wealth. It's pretty clear from the RSVPs and the attendees that we can see already online tonight that this is a pretty popular topic. A little bit about Libro as we go forward here. Libro, 36 locations across southwestern Ontario, 108,000 owners. We have over 700 employees proud to work on behalf of those owners. We're a B Corp certified organization, and we believe we have a purpose-based business model. Some of the ways that we're trying to manifest that purpose is through our 4 pillars, some of the areas that we're trying to influence change in southwestern Ontario: employment, financial resilience, local food accessibility, and housing. Tonight, clearly a direct link to the financial resilience pillar, and obviously a great link to Financial Literacy Month, which is ongoing as we speak. We are joined tonight by Doug Carroll. Doug has joined us for a number of these webinars in recent months, from owning a cottage to some year-end tax tips that we did late last year. Those webinars are available at libro.ca, and you can certainly review those replays anytime you want. Tonight's broadcast will also be available shortly after today on the website as well. Doug is a tax and estate specialist with Aviso Wealth. Perhaps we go back one slide there, Karen. It's a national integrated financial service company servicing the wealth management needs of virtually all of Canada's credit unions, as well as a range of independent financial organizations. Libro is proud to work with Aviso. They help us with our dealer services on the mutual funds, on our managed investment offer, and our insurance services as well. Doug, in his role, researches law, legislation, financial media in order to prepare support material for financial advisors and their clients. Doug's held roles in life insurance and the investment industry. Combined with his hands-on experience of running an estate planning law practice, he's certainly able to offer some very practical insights and wisdom in these very personal wealth matters. He has contributed to and is quoted in many financial media, including the Globe and Mail, National Post, Toronto Star, BNN, CTV, and I could go on for half an hour, so I don't want to embarrass Doug on all the places that he's appeared on these topics. Doug, in terms of expertise, has a bachelor's degree in business administration, a Juris Doctor, Master of Laws with a specialization in taxation. He's a trust and estate practitioner and a certified financial planner professional. He previously sat on the board of directors of the Financial Planning Standards Council, now FP Canada, the overseeing body for CFP professionals. And what we like most about Doug is when he talks about law, he's actually speaking in a language we can all understand. Now, our webinar program tonight, just a couple best practices for success. Just given the nature of the webinar, it is a bit one-directional. We can't hear you, and we won't be able to see you. So if you do have questions for Doug or comments that you'd like to add, please use the chat feature. We'll certainly publish the questions. My job as moderator is to find some of those themes that make sense and to bring those questions into the conversation. We do know and expect that on a topic like estate planning, there may be some extremely personal questions, and this may not be the most appropriate forum for all of them, but we'll do our best to answer the questions we can, and we look forward to your comments. Doug, I'm going to turn it over to you.
I'll unmute myself so that you can hear me now. And Paul, my slide's up there. You can see the visual up there. Okay, great. All right, so I'll get into the topic here. Oh, just a second here. There, my screen went blank. I'll get into the topic here, and I just want to let everyone know, because this may happen while I'm speaking here, I have heavy allergies at times, and they're hitting me last few days. And so I do have my water handy. And so if I get a little bit of a coughing fit, don't worry. My wife and my kids are off screen here, and they'll rescue me. I don't know if they can pick up the conversation on the topic, but I'll be safe. And so this topic is the not necessarily the completion, but it is the action side of estate planning, in that when you're doing your estate planning, you are thinking broadly in terms of what you're going to put together for yourself to take care of the important people around you. And a key part of that is deciding what you're going to do with your estate, your estate broadly stated, as well as, of course, the core document, and that's your will, and how that will be carried out. And the key role involved with that is, of course, the person who you name as your executor. So I'm going to go through 8 topics here in a progression of topics. And I'll probably be about a half an hour of time, approximately, maybe a little bit over. And Paul is welcome to interrupt me if there are questions that come up that he wants to hold me up with, because you put them in the chat box, then we can deal with those. So I don't want this to be something where I deal with a topic and then I move on, and then something gets lost because it's foundation for the next bits that we're going to get into. So as I said, 8 topics that I'll go into here. And we'll start with talking about the appropriate characteristics that you're looking for in an executor. As I am speaking on this, just please understand, when I'm saying who might you choose or what are the characteristics you might be looking at when you're talking about an executor, for most couples, the likely choice that you're going to make is, and certainly in your younger years, is going to be back and forth, the two of you naming one another as executor and as attorney under the powers of attorney. But then as a second choice, who is going to be the alternate, that's really more what we're talking about here. Who among the important people around you, the people who you care for and you trust, who among them would you choose to fulfill that role? The other thing that I want to say is that I kind of bounce back and forth sometimes when I'm talking on this topic, from the standpoint of you, the testator, the person who's making out your will, and who you are choosing or thinking about choosing to fulfill that role as executor. And then on the other side of it, if you are the person who is asked to be an executor, what kinds of thoughts go through your head and what things do you have to consider? And really, it's mirrored, the kinds of things that are involved. But if I switch back and forth, just be aware that sometimes I'm just doing it from the one perspective or the other. Now, I'll give you a little bit of an anecdote here. When I was doing this topic over 20 years ago now, one day I was speaking on executorship, and the sub bullet that you see on the slide here, not just honor, it's something that I've always commented on, that if you're asked to be executor, a lot of people will feel honored in being asked to be an executor, but it should be more than that. And this fellow brought up a personal anecdote for him, which was current, in that he had been asked to be executor of a very close friend's estate some 20 years prior to the date that we were holding this seminar. And about 10 years after that, he had moved back to Ontario, and he had pretty much lost contact with this fellow who had asked him to be his executor. And then here he was almost another 10 years later, and about 2 weeks before the seminar was happening, he got a phone call from the daughter of this fellow who had asked him to be executor. He was in hospital, was not expected to live much longer, and there it was. He always had this in the back of his mind that he'd said that he would be executor, and it was waiting for him, but he really lost contact with him. And then the other shoe dropped, in that he wasn't the only person who was named as executor. There was a second person who was named, who was also a close friend of this fellow who was nearing death, except that the one who was speaking and the other one to be named as co-executor did not get along at all with one another at any point in time. So it was looking to be something that was going to be difficult. So he felt honored to be asked, and he said, sure, put me down for that. But he wasn't feeling all that great about it, and felt like he was caught between a rock and a hard place. Now, he did not have to accept the appointment necessarily on a legal basis, but certainly morally, he felt that he was compelled to have a discussion about it and discover or discuss with the family what it is that he would do. So I don't know what the final thing was on that, but being honored is certainly how a lot of people would feel, and there's nothing wrong with that. But you also have to step back and say, let's be practical about this. So here are some practical considerations. are you available to do the job, and are you willing to do the job? Now that might sound kind of silly, because most often you'll be asked to be an executor where the person is not actually in a terminal health condition, is looking out long into the future potentially, but just by the nature of who you are and what you can do with your time, are you available to do the job? Because it'll be a lot of concentrated activity at the point when the person dies to pull things together. And so if you don't have the flexibility to leave your work or to leave your business, if you run a business, to be available, to instruct, do those kinds of things that are necessary to do as an executor, then it could make things difficult for you, as well as creating some problems with getting the administration of the estate going. And the point about willingness is that if you're feeling that just because your parents asked you or told you that they're going to name you as the executor, that you kind of shrug and go, well, I guess I got to do it. If that's the way that you're feeling about it now, then once you get into working on the job, because it is a job, it is an effort that you have to put into being an executor. Once you get to that point, you may not be in the best frame of mind to do it, and that's going to be difficult for you, and it'll be difficult for the other people. It'll be difficult to get the job done in the appropriate way. So are you available? Are you willing? And then what kind of knowledge do you have? When you, I'm switching sides here, you as the testator are looking at the people who might do the job, is this somebody who has an understanding, an ability to deal with financial matters, with legal matters, with tax matters? Not that they are professionals in those areas, but those are the kinds of things that an executor is responsible for doing. So is this somebody who is going to take the time to learn sufficiently to be able to manage the estate, or to take instruction from the professionals that are available to them to do the work that will allow for this to get done in an appropriate way? Or is this somebody who's kind of a lone wolf, and would that cause some issues for you? Third thing here is the ability to be diplomatic. Unfortunately, what happens sometimes with estates, we have people who during their lifetimes may have some feuds among them, small or large, and while their parent, particularly mother, father, both, are living, those kind of problems are kept down. But once mom and dad are gone at the point of the death, then you have the gloves off, and that's difficult to manage with. As the executor, you are not legally required to be the referee in those disputes on a personal level, but you do have a responsibility, and you will be seen as being the center of managing things. So are you able to manage that, the difficult personalities, the infighting that might be going on or anticipated, and still get the job done right, particularly if you are one of those people who's perhaps been a little bit in that fray? And then the last point that I want to touch on here is the executor, the named person who is the executor. It's important that that person has their own estate planning in place, because what you're doing with your estate planning is you're trying to get some certainty as a testator making out your will, a certainty as to what is going to happen with your estate and who's going to take care of that. So you want your executor to be there at that time, or if that executor, unfortunately, is unable at that point, perhaps becomes incapacitated or dies during the course of the estate administration, then you want their estate planning also to be in order, because one of the things that can happen is the executor of the executors of estate may have to step in and pick up the first estate to get things all done. So get everything in order. It's a good opportunity to talk to the next generation to say, you need to get things in order like I am. Finally, in that little box there, the use of a professional trust company. That used to be something that might have only been considered by people who are ultra rich or richer. It's much more common these days. Estate administration has become much more complicated. The processes involved, although the Ontario government has just introduced some simplified measures that maybe is going to take it in the other direction, but still, it's a pretty detailed kind of job, and there's potential liability involved. So having a professional trust company, considering that, is not a bad idea. You won't be charged if you reach out to a trust company to ask. And so it's worth considering doing something of that nature. So I'll leave it at that and leave that with you. Paul, I'm going to take a sip of water. Just wanted to know if any questions have come up already.
There are a couple questions specifically around who has to sign, who can act, living in the same province, but I think you may have some of those technical details ahead, correct?
Yeah. Yeah, I'll touch on that. Hang on to that thought, because I do have something, but I don't know if I have a bullet directly on it, so I may miss it.
I'll
but
make sure.
yeah, you hold me to it. Okay. Okay, so this is the legalistic topic that I'm going to touch on. Now, I'll try not to go too deep on this. We hear this word fiduciary sometimes used in general conversation or general media, but it has a very firm legal meaning, in that when you are an executor of an estate, you are a fiduciary, and fiduciary can apply in different circumstances. But in this case, it's because you have certain knowledge and power in that you become the legal owner of the deceased person's property in order to manage it, because you're the trustee over the deceased estate. And because you're in that position, those beneficiaries depend on you to execute that authority at the highest level of responsibility, and that's what a fiduciary is. So these points here, acting reasonably in good faith, personally, even-handed, loyal, what they're referring to, I'm not going to go into each of those, but what they're referring to is basically that you have to put the interests of the estate, and in turn the beneficiaries of the estate, ahead of your own interests. You cannot profit from being the executor of the estate, except to the extent that you're entitled to compensation, which is the last thing that I'm going to touch on towards the end. So you can't use the information for your own benefit. You can't use the property for your own benefit. I'll give you another anecdote. There was a case some years ago that involved an executor, somebody who was named as an executor, and he came to be the executor. He took over the property of the deceased person and moved into his house, started hanging around at his cottage in Muskoka, renewed the tickets for the Blue Jays, and that went on for almost 10 years before the people surrounding it came to realize that the estate was not being administered properly. So it's actually a reported case. I won't say who it is, but it is actually reported in the courts. I was speaking on that particular anecdote one day, probably about 12, 13 years ago. And one of the people afterwards came up to me, and he gave me a few more details about what had happened in this case. I said, "Hi, how did you know about that?" He said, "Because we are the next door neighbors of the guy who died, and we also thought that this person who was living in the house had bought the place, not that he was an executor abusing his power." So that is the bad way to be an executor. If you're acting as an executor, best interests of the beneficiaries of the estate has to be your priority, and you have a job to do, and you're entitled to compensation, but you can't abuse that by using the knowledge you have and the property for your own personal benefit. So I mentioned the person that that attended that seminar long ago, and his discomfort with accepting the role. Because you are named as a benefit or as an executor on a will, you are not legally obliged to actually do it. And in his case, it was difficult because he had given his promise that he would carry that out. But you are not legally obliged to do it. Excuse me. But if you start acting as the executor, if you start dealing with the property of the deceased person, if you represent yourself out to the world as being the executor of the estate, then you may be compelled to continue doing that. And particularly, and I'll touch on this one in just a minute, particularly if you go through the formal probate application process and are confirmed by the court to be in that role. You can't just step away and say, "Oh, this is too much, I'm going to stop doing this." So once you are in the role, then it's going to be difficult for you to step back out of it. So you want to think about it very carefully, whether you want to accept the appointment to be the executor of the estate. And when you are appointed as the executor of the estate, you don't have to do it entirely on your own. You can hire professionals to do the legal work, the accounting work, if it's complicated tax filing that needs to be done. You can hire real estate agents. You can hire other professionals to do those things that require professional skill. You're not required to personally do all of those things, but you are required to personally oversee what those professionals are doing and make sure that they do what they are supposed to do for the estate, and the cost of hiring those professionals goes to the estate. So it's not your personal out-of-pocket cost to do that. Now, what happens if you are named as executor and you say, I don't want to do that, I won't take that on? Well, in that case, the will of the person remains the will. So it still is going to be how the estate is going to be distributed. It just becomes unclear who is going to carry out that job. So the the people who are connected to this deceased person can apply to the court to act as the executor in that case, to take over the job, and it's generally going to be close family members. It could be a beneficiary if it's not a person who is a family member. It could be a beneficiary who is non-family member. It could be parents of those beneficiary if you have a minor beneficiary, for example, or it could even be creditors. But just because the executor does not accept the role, that doesn't eliminate the will. The will still speaks on behalf of the person. Yeah. Okay, so I said I was going to talk about what happens with the court process. When you have a will, you as the person, so switching roles again, I'm going to be the executor now. When the executor has the will and wants to take care of the management of the estate, the first thing they do is identify the property of the deceased person and collect that property up. When they go to the various parties, we'll call them that, who have property of the deceased person, those parties, and financial institutions, for example, would want to make sure that the person who is standing before them is legally entitled to actually take control of the property. So what they'll say is, we don't have anything against you, but we've never seen you before. We don't know if that document there is perhaps improperly executed, or maybe it's a forgery. They're not going to say those things out loud. But what they will say is, we need you to probate that will. And what that means is they're asking the executor, or they're telling the executor, to go to the court, fill out the necessary forms, and prove to the court that this will does govern this deceased person's property. And once that happens, then the court gives back a court-sealed certificate that then confirms that the person named as executor can operate under this particular will. So we refer to that as the probate process. Probate is not the official term in Ontario anymore, but generically we refer to it as the probate process. The document that you get, excuse me, here. The document you get back is referred to as a probated will, which used to, back in time, say on it probate or probated will. Now it's a certificate that confirms the appointment of the person as the executor. And the charge that the court levies is the probate tax. And in Ontario, we have a probate tax when property goes through the estate. The probate tax is half a percentage point, so 0.5%, or sorry, 1.5% of the value of the estate. It used to be half percentage point. Now it's 1.5%, and that's all the property that flows through the estate is subject to that 1.5% tax on the amount over 50,000. So the first 50,000, no probate tax, but everything over that, it's 1.5%. So if you want to get around that tax, and remember, it's only 1.5% at its worst. If you want to get around that tax, you can do that. You have to be careful that you don't have other problems that arise when you have the avoidance of the probate, but there are some common ways you can get around the probate without it being doing something complicated, or generally being any more problematic than taking these steps. So the three common things that we tend to have is, if you give things away during your lifetime, you don't own them at death, and therefore they don't fall into your estate and are not subject to the probate tax. Don't go overboard with that. As you may recall, any of you who were at the earlier session that I'd spoken on, we were talking about estate planning. My law practice, as I ran it, which I ran for about a decade or so, I saw people in their homes in the early stages, and quite often I would see elderly people who couldn't get out to a lawyer's office, And I had quite a number of situations where people who were living in their own home were looking at trying to avoid probate as their primary concern. They were willing to give away their property to their own children because they trusted them, and I wouldn't question whether they trust them, but it's just putting them in a difficult position where they're giving away ownership to their property, to their house even in a couple of cases. Their intentions were because they wanted their children, their adult children, to take care of them, and so they could avoid the probate tax. So it's okay to give away some things during your lifetime if you're trying to advance the point at which the people are going to receive those properties, that property, and not have it go through your estate. But be careful about doing that with large property that you depend on, like your home. That could put you in a difficult position. And then once you give it away, not that your children are going to do anything wrong to you, but if they end up with creditor problems, if they end up with a marriage breakdown and they intermix property and ownership, it could be really, really difficult. But you can use gifts to get around probate. You can also use beneficiary designations off of insurance plans and off of registered plans. So pensions, RSPs, RIFs, those things that you can name a beneficiary on. When you put the beneficiary down, the person who you name as a beneficiary, and it could be more than one, they receive the property in that particular plan. It does not fall into your estate, so it's not subject to the probate tax. And then the third thing that comes up quite often is joint ownership of property. And when I say property, people generally hear real estate, but property falls into two main categories: real property, which is real estate, and then personal property, which is movable things, including financial accounts. So you can hold property in joint ownership. Most often we think of real estate. And with a couple, quite often that's what you're going to do with your house. You're going to own together as a couple. The benefit of joint ownership, and you can have more than two people, and you don't have to be a couple in order to do this, to have joint ownership. But the benefit of it is that when one of the joint owners, you've got two people, one of the joint owners dies, rather than the interest of that person falling into their estate, it goes over to the other one or more joint owners by right of survivorship because of the way that you hold title as joint owners. Between two people who are a couple, that's probably the best way to do things because it streamlines the administration of the estate when the other person is going to be your primary, if not your only beneficiary on a first death. Where you get beyond that, where you have your own children perhaps that you wanted to add on to joint ownership or anybody beyond that, then you have to be a little bit more careful because whereas a couple has a closeness of their interests, their legal interests, they're going to take care of one another. Where you have others involved, you don't necessarily have that same kind of identity. I don't mean identical, I just mean identity between you. You also, between spouses, you can transfer property without triggering taxes, which is not necessarily the case where you have a non-spouse involved. You also potentially are exposing to, again, creditors and matrimonial claims with those others. There's not really a consideration where you got the two as couples. So certainly you can use joint ownership to get around probate, but make sure that you get legal tax advice to make sure that you understand what will happen before you go about doing that. I'm going to hold up there, Paul. I'm going to take another drink of water. Just want to see if there's any questions before I continue on.
Yeah, there's a few questions, and some of them are relevant here. There was a question earlier about, it's more of a best practice question. I'll give you both questions because you may want to answer them in different order, but a best practice question around, would it make sense for the testator, person writing the will, to provide details on, accounts, locations of accounts, statements, its property, etc. And then a follow-up question that's going to be published shortly. Before you have the will probated, the certificate of appointment of estate trustee in Ontario process, then do you have to list the value of every asset, such as a home?
Right. Okay. So, excuse me. In terms of, so taking the first question, because there is some connection between those two, it is helpful for the person named as the executor to have a summary in some way to work from. What you don't do, in any cases that I've dealt with or that I'm familiar with, you don't list off your assets directly in the will, though. You have it somewhere. You have it in a document that helps out that executor to know where to start and be able to identify who's got what of the property to collect that in. If you had listed that property directly in your will, then as there are changes in the nature of that property, it could change the distribution of your estate. And I think that everyone wants to have full employment, but do you really want to have full employment in your lawyer's office by constantly going back there and redoing your will over and over again? I think not. So you don't generally list all your property in a will. Very significant large properties may be listed if there's something special about those things that you want to transfer those on in a particular way to family members. Maybe a grand old cottage that that has some really significant transfer needs for that. In terms of the probate application process, and I know I'm using the generic term here. In terms of that application process, the way that it works in Ontario right now is you do the application for probate to the court to get the person who is the executor put into that position. And as Paul was just mentioning, the proper term there is actually estate trustee. Executor, everyone still says executor because they understand what that means. The term, it varies from province to province. And in Ontario, it's actually formally the estate trustee. Executor means to execute the instructions in the will. Estate trustee is pretty much descriptive. The estate is a trust, and so the person who's in charge is the estate trustee. So with that process, there's a two-step process to the probate application in Ontario. You apply to the court to have confirmation of the ability of the will being the will of this person, so that the executor can be cloaked with the authority that the courts will give on confirmation. That's step number one. And then step number two is you have to then submit to the Ministry of Finance a listing, a detailed listing of the person's property. And that then in that detailed list of that person's property is where you have the full or very full disclosure of the person's property in that second step of things. At the first step in the application for probate, you have to put down what your estimate is. And it's not just, oh, I'll just ballpark something. You do have to have a reasonable estimate of what the property is of the person when you do the original application. But then when you do the detailed application or detailed summary to the Ministry of Finance, it may be that there is more involved dollars-wise than what you thought in the first place, and in which case you will be under an obligation as the executor to top up the amount of probate tax that would have been due when you made the original application to the court, because you have to pay the probate tax when you do the application to the court. So I think I covered off both of those things.
You did, yeah. And just
okay.
Yeah. I'm glad you brought up the silent partner that any executor would have in the process with the CRA and the tax obligations. What about there's a question, the follow-up question on that about listing and getting the appointment of trustee. Can you sell any property? Could you sell the home? Could you sell a car? Could you do those things? Could you start that process at all before the probate process is completed, or is it better to wait in most cases?
Actually, there's the best word you had in there was better, because can you sell? You may be able to. I certainly have. I've seen situations where someone has been able to do a lot of things without having the formal appointment in place, and then the appointment comes in and they finish things off. But it is better to wait until the probate application has been confirmed through the courts before you as executor do those things. And likely you're not going to be able to do a lot of things, because you won't be able to take hold of those assets of that person until you've got that formal confirmation, particularly for large assets, getting financial accounts into your hands, or signing off on the sale of something like, well, even a car, but particularly if there was, excuse me, real estate, you won't be able to transfer that without having a probated will. So you can do some things, but you're not going to be able to do the large things until you get the formal appointment in place. Okay, so let me continue on there. I've already made reference to the collection activity. So you, as the person who is named as executor, there's roughly 3 stages involved when you're acting as the executor: collecting in the property of the deceased person, doing the management activities, the administration activities, including filing the taxes for the person. And then once that's done, distributing out the property to the people who are the beneficiaries. So there's your three main stages of things. So when you are asked to be an executor, one of the things you could do, for the sake of knowing what you're getting into, is ask the testator, could I see the will? And when I say that, there's no legal obligation on the testator to show you the will. And depending on your relationship, you could read something into that or not if you're not able to see that. But it's really the idea that you want to open up the dialogue to make sure you know what you're getting into and that you're clear on what the expectations are for the testator. So if you're looking at the will, it's not your opportunity to wordsmith what you see in front of you or to influence the testator on what the testator wants to do with their property. But if you see a distribution which is surprising to you, and I guess not up to you, but if you see a distribution where it disproportionately adds more to some beneficiaries or less to others, then it might be something that might be a concern for you to be the executor who is going to have to communicate that and execute that instruction later on. So you may want to know that that's what you're getting into. And if there's something that is particularly surprising, then you might want to ask the testator, I'm going to be the one as the executor who is going to have to do this and explain it. Could you help me please on how it is that I'm going to explain this? So that might be an opportunity for you to learn more in terms of what the role you're going to carry out and decide whether in fact you want to do that. So, Paul, you mentioned the summary document and a starting document that does have a listing of the property of the testator can be helpful to allow for the executor to get that step up to get things going, to know where to go to collect these things of the deceased person. I think we shared out the state information form last time around when we were talking about estate planning, but certainly it is open. Anybody who wants that, we can share that with you following on this session, which is a summary document where you can write down the information about who you are and the important people around you and your professional advisors and the key property that you have, so that the person who is acting as the executor has something of a starting point in making use of that document. So one of the things that comes up in movies is that the executor of the estate is doing all sorts of money maneuvering, perhaps. That's the image of it. But the truth is that with an estate, usually what you're doing is, as the executor, you are collecting in that property and you're parking it. You are protecting it so that it is available for distribution out to the beneficiaries once you get to that stage of things. You are not actively managing that money usually in the estate. But if there is a trust which is going to be set up because there is someone who is a minor beneficiary, maybe there's a 2-year-old that you have to be the trustee for that 2-year-old until they reach the age of majority, or maybe even beyond that if the will says a longer period of time. And it may be that you are the trustee in that case, continuing on after you take care of the executorship, or you get to the point of finishing off the estate management, and then you turn the property over to someone else who will continue on as trustee. But whoever it is, whether it's you as the executor continuing as trustee or someone else who is named that you will then provide the funds to, in that case where there's longer term management of property for one or more beneficiaries, then there will be a need to make a decision about how that money is going to be managed and how it is going to be invested. Sometimes the belief is that you just be as safe and conservative as possible, but the truth is that there is a positive obligation on the person who is acting as trustee to execute their function as the trustee, and that will mean making decisions about making sure that this money is protected. And inflation can erode the value of property. So if you're ultra conservative, you could end up with this 2-year-old you could end up with reducing down the effective value of the estate or the trust for that person if you don't take an active role. And that's not to say that you go way out there, but you do have to evaluate things. And that's where there is a role for a financial advisor to give you advice, one, to give you the advice that you yourself don't have, assuming you're not a financial advisor. And even if you are, you probably should have an independent advisor who you are working with to do to help you with this. So you are getting that advice, and you are showing that you are getting that advice. So if there's ever a question how you've done the job, then you can show, I was being responsible in this. I hired a financial advisor. We put together an investment policy statement. We then invested the money in alignment with that investment policy statement. And the last point that I have here is that kind of conversation with the financial advisor is necessary for the kind of expertise that the financial advisor has to make sure that you are dealing with market risk of investments, knowing what products there are available, and making sure that there's an appropriate risk discussion and allocation of the investments according to that risk issue. You still need to verify that you as trustee are doing what you need to be doing legally, as well as from that financial standpoint. So make sure that you verify with the lawyer who you're doing the estate with to make sure that the investments that you are putting into align with the responsibilities you have under the terms of the will, which then becomes the trust on this ongoing basis. So it seems like it's something where, again, I'm trying to employ more lawyers. But if things go wrong and you've done things that you feel are appropriate from your standpoint, you've done your best with it, but it doesn't line up with the legal responsibility, the danger is that 2-year-old, and courts will lean towards protecting the beneficiaries over the trustees. So you have to be careful that you are keeping within the lines, okay? So now we get to the point where you're ready to distribute the property. The first things that you will have done when you gathered in the property is make sure that you've identified who any creditors may be for the deceased person. Where there are legitimate claims, you have paid out those things. You have taken care of the tax returns of this person. So any past returns that had not yet been filed, you take care of that. There will be the terminal tax return, which is January 1st to the day the person dies. And then there will be tax returns related to the estate itself, which begins the day after the person dies. And so if this goes on for more than a year, then there'll be one, and then a second one, maybe a little bit longer. Now, sometimes people will say, well, why does it take so long to administer an estate? And it's because tax slips may not be yet available. So 18 months is usually the kind of time frame that's involved with managing an estate. Even if things aren't really complicated, it might be that long, because you need to get the property in. You need to take the time to get the appointment done for the probate application, and you need to then file the tax returns. And then once you've done the filing the tax returns, you as the executor can distribute out to the beneficiaries. So as I said, the 3 steps involved: collect, manage, and then distribute. But having said that, if you are the only beneficiary, this is a spouse-to-spouse thing, then you're the only one you have to account to yourself. You can just say, fine, I'm just going to take it. If I did something wrong, then I'm the one who's going to pay for it. So I'm not really concerned about things. But as you get away from that point where you as the person are both the executor and the sole beneficiary, there's a difference between you as the executor of the estate and the beneficiaries. And particularly as you get further away from that, if you've had difficulties in the course of managing things, you want to be careful that you are crossing your T's and you're dotting your I's. So one of the things that you want to do is you want to confirm with the CRA that you have done everything that has to be done to file the person's taxes. And that's what a clearance certificate is. You fill out the paperwork for, and when I say the paperwork, it's a form. You confirm what you have done to take care of the tax liabilities of the deceased person, and you file that with the CRA, and then it goes into the queue. Well, it's last in, first out, or first in, last. What is it? It goes on the pile, and they go through the queue, and then eventually they'll get back to you and they'll confirm to you that yes, based on what you've given them as information, you have dealt with all the tax liabilities, of the deceased person. And with that document in hand, you know that when you distribute out the property of the deceased, there's no further tax liability involved. So it protects you as the executor in doing that. If you distribute the property and you don't have a clearance certificate, and then it turns out that there was an error, some assets that you didn't account for, and there's more taxes that are due, you've already distributed out to the beneficiaries, and CRA is going to say, well, that's unfortunate. That's unfortunate for you, but there's taxes due to be paid, and you personally might be liable for that. You may go to the beneficiaries and say, hey, I had this little thing happen. I gave you too much. Could you give me back some of those assets? Excuse me, some of those assets. They are not legally obliged to do that, to give back to you. So that's where the clearance certificate can be helpful to make sure that you don't get yourself into that kind of a bind. So once you've done that, then you can distribute to the beneficiaries. And the three main categories of beneficiaries are those who are entitled to bequests. So bequest is a particular thing, like a Lamborghini. That'd be nice, eh? The silver tea set, but particular things you distribute out to those people. And then next is legacies. Those are dollar amounts. So it might be $5,000 to each of the grandkids, $100,000 to the Cancer Society, whatever those things might be, specific dollar amounts. And then what is left over? It's called the residue. And the people who are entitled to that, they are the residual beneficiaries. That is usually the bulk of the estate once those specific items have been paid out. And it's those residual beneficiaries, for the most part, that are going to be the ones who you need to make sure are comfortable that you've done the job that you need to do. They're the ones who you are going to be reporting to when you come around to this compensation. So as I said, you are entitled to compensation as an executor, and it is a job. And when I do this in person, I always do the silly, how many people have ever acted as an executor? And a few hands go up, and I say, well, how many of you will do it again? And all the hands go down. So it definitely is something which is an important role. There is fulfillment involved with it, to have closure involved with it. But there is work involved. It's going to take time out of you. It's going to take effort. It's going to take some stress to do it, and you're entitled to compensation. Now, when you're talking about the amount of compensation, you propose to the beneficiaries when you report at the end how much compensation you're going to take. And as I said, it's the residual beneficiaries for the most part that you're going to be looking to, because if they approve your compensation, no matter how large it is, if they approve it, it's basically coming out of their entitlement, out of the distribution of the estate. And so when they approve it, great. They say, sure, you can have that giant amount of compensation, then that's the compensation. But if you have minor beneficiaries, or you have beneficiaries who don't have mental capacity, then the public guardian's office is going to act on behalf of them, and you're not going to get that giant compensation in that case anyway. So you do have to propose something reasonable. If nonetheless there is a dispute about what you feel you're entitled to for compensation, then you're going to have to go to the courts. You're going to have to do what's called passing the accounts, which is providing to a court officer the records of the things that you have done. So this is why good record keeping is very important, so that you can claim the compensation that you feel you're entitled to. So we refer to the common percentage, which is roughly about 5% of the value of the estate. And it comes out of case law. It's actually based on those three stages of collecting, managing, and distributing. So it's 2.5% of what you collect in, 2/5 of 1% of the average assets that you have under administration during the course of the estate, and then 2.5% of what you pay out. And actually on those drawing in and paying out, it's broken down between income that you collect and capital that you collect, and income that you pay and capital that you pay. So rounding the whole thing out, it's about 5%. And that is the high watermark of compensation that you might receive. To understand clearly when I say compensation, it is an income amount from an office, the office of being an executor. So it is taxable. So sometimes what people will do as testator, they will give a special gift to the person who is named as the executor, which is intended to be in lieu of compensation. Because if it's a distribution out of the estate, it's an after-tax amount, but if it is compensation, it is taxable. The only party that loses out on this is the Canada Revenue Agency if the person gets a gift rather than getting compensation. If it's too closely tied to the activity, then it could arguably be treated as compensation. But it is something that sometimes people will do. And by the way, on the second point here, if the compensation is stated in the will, how much compensation you're going to get, and you start acting under that will, or if it says you're not getting compensated, you are bound by that if you start acting under that will. So compensation is certainly something you are entitled to. It can be a large dollar amount, potentially up to 5%, as they say. About that's the high water mark that you're be entitled to get. But you will do the work in order to get that compensation. And if there is any kind of question about the quality of the work that you have done, then you want to have really good dockets and record keeping to back up your request for that compensation. So, Paul, I'm going to shoot it back to you again and see what remaining questions we may have. Back to my water.
Yeah, not a problem. And some great questions coming in, some real engagement here, Doug. Reminder that tonight's webinar is being recorded and will be available for replay at libro.ca after the event. There's a few questions in there that are more about estate planning, about sort of whom to name as an executor and different things, and we might defer that to that conversation. For example, can a trustee, I don't think they meant trustee, can the testator living in the US appoint an executor that lives in Ontario? So now we're getting into some international law and different things. So that one we might have to bring in for a very specific question. But probate is certainly striking a bit of a nerve here, Doug. And I know from experience working with our estates team at Libro that it often does. You're often working with executors, representatives of the deceased who are not at their best. Generally, you're not named to be executor unless you have a close relationship with the deceased. And so it's a difficult time. You're adding in complications like tax and everything else. And we get it, that it can be hard. So probate, there was a question about the spouse having to go through probate, but joint ownership with a spouse would, for most reasons, bypass probate, correct?
Yeah, that would get around it for that particular piece of real estate or that investment account, non-registered investment account. It would go to the surviving spouse without having to go through the estate.
A joint account and a named beneficiary on a registered product like an RSP, etc., would be able to bypass the probate, as well as a named beneficiary on an insurance.
Yes.
Policy. Okay. The question about probate, does it have to be done?
It doesn't have to be done. It is because you, as the executor, may not be able to take control of all the assets that you need to do the probate application for that reason. But there are a couple other reasons why you were going to have to do it, even if you don't want to. One is that, as I mentioned in a different context there, if you've got a minor beneficiary or somebody who is not legally, mentally capable of giving their consent, then the public guardian's office has to be involved on behalf of that person, and a probate application will be required by the public guardian's office in that case. And then the other thing that to bear in mind as the executor, if you're acting as the executor and you're doing your best job in doing that, you make an error, but you're doing it under a probate certificate, then you have a very high level of protection from any kind of personal liability. But if you manage to do things without going to the probate application and then something goes south on the management of the estate and there's a lawsuit, you could personally be liable for the things you did. So having that probate certificate, the certificate of appointment, is something that's going to give the executor that protection to rely on.
No, and I'll speak from some experience on behalf of the financial institution. We have had owners pass away, and it's a relatively straightforward estate. The spouse is named, joint on accounts, etc. And we're not likely going to require I can't guarantee it, but we might not require the probate process in that example. We also have situations where there's 5 or 6 children. Let's just say there has been experiences in the past where we're not sure who's coming or going in an account. And as the financial institution, we'll ask for that to be completed before we'll release those assets because we have a degree of liability on that process as well. So
Yep.
we're not doing it
Yep.
to be difficult, but sometimes we just have to do it.
Oh,
So some other questions.
Paul,
Oh,
I'm gonna throw one in myself because there was one
sure.
point that I should have made. On the probate applications, I mentioned that the probate tax applies on the amount above $50,000. Just this year, there's a change that allows for small estates to be managed, where you can go through a more streamlined process if the assets are no more than $150,000. But the probate tax still applies on the value above 50,000. It can be a way, if it's a fairly small estate, under $150,000 in assets, to speed up the probate process for those relatively smaller estates. Okay, back to you.
No, that's an excellent point. I've actually put a link in the chat to the Ontario probate page. It talks about that small estate process. It talks about the normal process, and it also at the very end quite logically says if you need legal advice, get legal advice on these situations. A couple questions. For example, Dave did some math, good math. $5 million estate, the probate would be about $75,000. Is the executor expected to pony up the funds for the application themselves?
There has to be the money for the probate on the application itself. Now, is the executor personally going to have to do that? If there is no money available in any other place, somebody is going to have to bring that money forward, which is a good reason why people will sometimes have one of their executor, an adult child, for example, as a joint on one account, which has some money to take care. Certainly, as you're older, having an adult child taking care of your financing can help out while you're alive. But it also could be a source of funds for getting the estate going. The may not be $75,000 that's in there, but that is one thing that people do. The other thing is life insurance. An allocation of life insurance for this purpose could serve to create some liquidity to get things going. And then once the executor is ready to go, then there could be a reconciliation of who's actually entitled to the full insurance policy proceeds thereafter. I know I'm getting a little bit complicated there, but using life insurance in that way can give you some liquidity to get things flowing.
Yeah, and it's a great example of where tonight's topic is really about the role of the executor, but it speaks to the importance of the person writing the will to do the right estate planning to make sure their wishes are looked after and it's as easy as possible for the people that are helping them out on the back end. Some other questions. Sorry, I'm going through this here. I mean, there was a question about the number of executors, and this would be the language in the will. The 2 executors named, do they both have to sign? And that would depend presumably on, and I'll turn that over to you, Doug.
Yeah, so I always say that if you're looking for efficiency of activity, there's nothing more efficient than a committee of one, but there's no oversight with that. So you can have as many executors as you want, but it becomes unruly and expensive the more the people who are involved. And if you do have more than one, the common types of appointment are joint, where they must do everything hand in hand, every activity, or joint and several, which means that either one of them can commit the estate for the activity, sign off on things. And for larger things, though, you're always going to have both or all of the executors sign off on larger things, because whoever's on the other side of that transaction does not want to get themselves caught up in litigation. They are going to require that all executors sign off there. But joint is tied together entirely. Joint and several gives more flexibility for the people to manage the estate.
Yeah, so I think there's a number of questions in here around compensation, and I think we might need to differentiate a bit between compensation to the executor and expenses incurred by the executor, and because those would presumably be 2 different things, or would that all get captured in the compensation piece?
No, the expenses of managing the estate, that is the estate's assets that pay for those things. And compensation is payments to the executor for the work that is being done. That may include reimbursement to the executor, where just because the executor paid something out of pocket, and so they're getting paid back for that, including that example you gave of the original money going for the probate. That might be a payment back to the executor who paid an estate cost. But otherwise, when we're talking about compensation, we're talking specifically about the payment to the executor who personally is entitled to take that for their own use.
Okay. And I know we're at 8 o'clock, but we've got some good questions here, and we're not going to keep everybody too much longer. But there was a question here about, you talked about 18 months might be a reasonable time period to expect from start to finish to fulfill all your obligations as executor. We have a lot of Canadians now living in what they're sort of referring to as maybe either the sandwich generation, where they've got parents and children at home, or they might be living in a parent's home. There's an example here of living in the parent's home as the primary caregiver. So the parent owns the home and passes away, but the caregivers live there. Again, good estate planning could help address that question in advance, but how do you deal with stuff like that after the fact?
Yeah, and that can get quite complicated. I was speaking to someone who is in exactly that situation with an advisor. They're trying to work out how they manage things in that case, where the original owner, the parent, has now moved out and has gone into long-term care, and there's been crossover of people who've been living in the house. And so that creates a lot of complication, not bad complication, but does create complication in that the house that you live in, that you own, is your principal residence. From a tax perspective, the capital gain on that is not taxable. But if you own it with others, then it becomes a little bit up in the air who's entitled to claim that and who's got what percentage of the value that's involved with that. So I do think, as you mentioned, Paul, I think that is a good practice to have, where you've got caregivers in the house. But also it sounds really again, making work for lawyers, but making sure with a lawyer whether there are changes to your legal rights by living together, and particularly ownership on that property together and living in that same house. That should be clearly documented, because it wouldn't surprise anyone that sometimes what happens is one of the local children ends up on title to the property so that they can take care of mom in her later years. And then the other children who live further away in another province believe that is just for the sake of the efficiency of the management of the estate. But the local child is looking at it and saying, woohoo, got a house. And that is not going to be the nicest conversation among them later on. So making sure that it's clearly stated why the ownership might have changed in that situation, and making sure that you get legal advice on it, is really important once you have those kind of group living arrangements.
Okay. Doug, there's a few more questions here. I'm not sure we're going to get to them all tonight. I genuinely appreciate the type of questions that are coming in. There was one at the beginning about adult children with disability and or not ability to look after themselves, and what the executor must or must not do. I'm not sure that's one we could answer on this call tonight without a different view of specific circumstances, but feel free to jump in.
No, and there's too much there to there would be too much that we'd say, well, what about this fact, what about that fact? But one thing to be aware of is where you have dependents of a deceased person, usually that's going to be minor children or spouse, and those people are not adequately provided for under the deceased will, then those dependents can apply for what's called dependents relief. So they can continue to be supported by the assets in the estate, even though they might not be named as beneficiaries or adequate beneficiaries under the estate. And that can include disabled children of the deceased person who are dependent upon that person during their lifetime. So it's called dependents relief, and it's actually in the key legislation in Ontario's Succession Law Reform Act that it is possible to apply for dependent support.
Right, and there was another question sort of related about an intellectually disabled child, where there was powers of attorney on the estate, but it doesn't. I'm not sure from the question whether the power of attorneys apply to the deceased or to the children, because if they apply to the deceased, then they would end at the time they passed away, and the will would clearly take over at that point. But that might be one. Again, that a bit of legal advice is probably likely in that one. It has to do with the public guardian's office. They'll get involved. Can they get involved on the estate side as well as the alive power of attorney side? If that makes sense.
Yeah, possibly. Like, yeah, I don't think we have enough
Yeah.
details, and even if there was, there's a little bit too much to dig into. But where you have people who have legal incapacity in some way, then you may be dealing with the public guardian's office, and they are there to take care of those people. But they do operate more on a bureaucratic way, and I don't mean that in any way negative. But they have to do their paperwork. They have to cross their T's and dot their I's, which could make it much more time-consuming and difficult to manage an estate where the public guardian's office is involved.
Yeah. Okay. There's a question here about adult child. Can an adult child be named beneficiary of an RSP, or must it go to the spouse? Well, you can name anyone you want. You might have to explain to your spouse why they're not surviving spouse, why they're not the beneficiary on your account, and presumably the taxation would be different for the adult child versus the spouse. Does the executor only get paid at the end? Can the executor collect expenses and/or compensation throughout the process?
Yeah, so technically the executor is not entitled to compensation until the very end. But if the executor is in a position to be able to distribute the assets at an earlier point in time, maybe most things are taken care of and they're just waiting for that clearance certificate, the executor could say to the beneficiaries, hey, listen, I can do an interim distribution to you before we get to the very end of the administration. And since I'm doing this interim distribution, could I get some compensation now? And the beneficiaries don't have to agree to that, but then the executor doesn't have to do the interim distribution. So maybe there could be an earlier payment of compensation if the beneficiaries agree, but otherwise technically it's at the very end. And again, if the public guardian's office is involved, then it's likely going to be waiting until the end or near to the end once all the main activities are done. Possibly just awaiting a clearance certificate, you may be able to get some compensation if everyone is agreeable at that point until that certificate comes in.
We're down to the last two questions, I promise, Doug. If any new ones come in, I apologize to our guests this evening, but we'll have to defer them beyond these two. We did commit Doug till 8 o'clock, and he's been generous with his time, staying a little bit past tonight. My sister bought a house with my parents. She lives with them. How should that be handled if I'm the executor when my parents pass away? My short answer was going to be very carefully, but Doug, I'll let you give a little more detail on that response.
I think that's the response. Again, we don't have enough details involved there. If you have people who are equally contributing in their money to purchase a house and they put their name on title to the property in the way that they agree among themselves, then so be it. But if the parents actually are the source of the money that is the purchase of that house, and the sister has been added on at the gratuitously by the parents, then potentially she is on there that it will avoid probate. But otherwise, when the parents go, she may be holding on to that piece of real estate for the benefit of the estate. It's really not clear from the points that are there, and that's not being unfair to the person who put that down, because there's a lot of things that need to be checked off to see what's going to happen.
Yeah, I'll share a bit of a personal. I mean, it's personal. I have 6 siblings. I kind of hope that my parents have found a corporate executor, because I'm not sure I want to personally deal with all of that. This question here, though, I'm not 100% sure, and I apologize if I don't do it justice. The parent who's the testator is living in long-term care with a contracted facility. Time to pay that out. What is a reasonable time? So presumably, if a parent in long-term care passes away and the will kicks in, I imagine the long-term care facility must have some contractual stuff to address those kind of situations. But any general advice?
Well, you go to the contract that's been signed for that, and that facility, that organization would be a creditor. Again, that's the executor's responsibility, is to identify anyone who has a claim on the deceased person. And so the executor would then ask them, what are you claiming and why are you claiming it? Evaluate it, and then deal with it, pay it if it's a legitimate claim.
Yeah, and I know here at Libra, our estates team deals with a lot of complex situations. There are some bills, funeral home expenses, for example, that we will pay directly to the funeral home to get things like that done on behalf of the deceased, long before probate stuff is finished and all of that is done. I mean, there are things that are reasonable, and there are ways for your financial institution to help in the short term, but obviously there's a lot of complexity to these situations, and they're all a little different. Doug, any final thoughts for us tonight?
Well, again, we threw a lot of things at people, and I do believe, coming back to the very first point that I was making about being honored, I do think that it is nice when you are being asked to be executor, that you do have that opportunity to do something that will complete the process. As someone was saying to me recently, I really want to die neatly. It's like, oh, okay, well, good for you wanting to be that organized. But it is nice to be in that position, to be able to wrap things up, to tie up the loose ends, and take care of things. And it is nonetheless a job. So don't do it just for the honor. Do it because you really can do it. And as the testator, choose someone who you feel is going to do the job right, and make sure that that you don't let the emotion of it make your decision. Have that as part of it, but decide who has the skills to do the job.
Excellent. Okay. Thank you, Doug. Genuinely appreciate the information tonight. There's a lot to absorb. There will be some follow-up materials that we're going to share with all of the registrants on tonight's email, and hopefully you find some benefit from those, and certainly encourage those of you who have a Libro coach and have questions, by all means, reach out to your coach. The first coach you get hold of might not have all the answers, and that's okay. We can help find people who do. We have specialists in estate planning. We have specialists in financial planning. We have specialists in estates, and we have to reach out for help sometimes too. There's nothing wrong with any of that. At Libro, we hope we're here to help. As you may have noted, it's November 10th. Doug and I both have our poppies on tonight. We do encourage you, if you have the opportunity tomorrow, to pause around 11 o'clock and reflect on those who sacrificed